Okay, welcome everybody to First Thursday. And today we have the pleasure of speaking about the asset protection cases that we consider pretty important for domestic asset protection trusts. So my name, of course, is Douglas Lodmell, and I am the co-founder and managing partner of Lodmell and Lodmell. We've been around since 1997, almost 20 years now. Can we believe it? And I'm also the founder of the Asset Protection Council. And the Asset Protection Council is a nationwide network of attorneys that are dedicated to using the proven solutions that we've developed over these past 18 years, not the least of which is the Bridge Trust, which is really a revolutionary concept in asset protection. And we'll see today, why I think it's so valuable as we go over some of these domestic cases. So again, welcome all. So domestic asset protection trust planning. Let's just kind of set the stage here. So we know that the Foreign Asset Protection Trust was first on the scene, and they were on the scene way back in 1984 when the Cook Islands passed the first Foreign Asset Protection Trust statute, which allowed for a self-settled spendthrift trust. That's what an asset protection trust is, a self-settled spendthrift trust. And those became very popular, but not widely adopted because I think they were foreign. And a lot of attorneys and a lot of clients were uncomfortable in the foreign jurisdictions. Fast forward to 1998, and Alaska says, hey, I think this is a great idea. Let's allow our residents to set up an Alaska domestic self-settled asset protection trust. Well, Nevada could not be left behind as soon as they realized that some other state was going to do something cool, and so they rushed to be on board, and Delaware can't be left behind. And then next thing you know, we've got 16 U.S. states that all have some form of domestic asset protection trust legislation. You see the list there, and growing. I expect there will be more. And as with a foreign trust or even the Bridge Trust, these trusts are often paired with LLCs or limited partnerships to provide additional charging order protection, which we like. We think that's a good thing. So the perception right now in the domestic asset protection world is that the advantages over the international planning, the foreign planning, are really based on costs, comfort of the client, distance. Theoretically, a client can jump in their car and drive to Alaska or drive to Colorado. There's a much lower IRS burden for domestic, or even really no burden, and perceptions of legitimacy. A lot of clients still are worried about offshore. So those are the good things, and I like those things too. I really, I don't like to file FACTA disclosures and FinCEN 114s and 3520s for foreign trusts unless I really have to. Of course, if I really have to, I really want to. So that's what's important to make the distinction. So that's why these trusts have actually gained quite a bit of popularity. I would say that they are becoming popular. I don't think that they're standard by any means, and you're going to see why. And I think that there's starting to be some real questions around their use. Again, you'll see why today. But because of the benefits, they really kind of have gotten a foothold. So now the question is, what are the considerations if you're even thinking about a domestic trust for a client? So here's the disadvantages. Article 4, Section 1 of the U.S. Constitution, of course, is the biggest, which is the full faith and credit clause, which we all know means that Nevada must respect a judgment from California. All states must respect judgments from other states. That's what full faith and credit means, that each state shall grant every other state full faith and credit of their laws. That's why we don't have to get a new driver's license when we drive across state lines. Your driver's license is good. The other state will respect it. Same is true for judgments, though, and court orders. The other states have to respect those too. So anytime you're trying to use a state under one constitution as an asset protection venue for another state's judgments, we have a problem. So the other problem with the domestic trust is bankruptcy exception 548E, which we're going to go over in one of these cases, which is really an important one. We've also just got straight up conflict of law issues. Is Utah really going to respect the Nevada declaration of jurisdiction on the trust for the two Utah people that are sitting in the Utah court. And you've also got lots of statutory exceptions within the DAPT statutes themselves. So even the states that have DAPT legislation, there's really a fair amount of exceptions to the protection, which in the international version are just not there. There's virtually no exceptions to the protection. Whereas in the domestic, there are actually a pretty long list of exceptions, which can be used to break into the trust. So, the result is, in my opinion, a landscape where a domestic asset protection trust is at least as likely to be disregarded as it is to be respected. And that puts me back into a coin toss with my clients, and I'm not very comfortable with that. I kind of like sure things, and I certainly like to be able to tell my clients that, we've put their assets in a jurisdiction that is very difficult, and they're going to have to go far, far away to try to collect on the judgment. But, lots of clients have these, so let's understand them. So let's talk about some cases. I'm going to go over 3 cases today: Batley versus Mortensen, Kilker versus Stillman, and Dahl versus Dahl. If you're in the asset protection world, these cases will be familiar to you. If you're not, then after today, they'll be familiar to you. And they are all very good cases to kind of illustrate some of the issues with domestic trusts. So let's start with Batley versus Mortensen. So in 2005, Mr. Mortensen, who's an Alaska resident, creates an Alaska Asset Protection Trust. And Alaska was the first state to do this, and he's a resident of Alaska, and that's the ideal situation. He's completely solvent when he does that, and he doesn't even have a lot of assets. He has $140,000 in assets. For the average asset protection client, that's really the low end. I mean, most clients have $1 million or more. So he's really just a small fish, but he wants to hold on to what he's got. It's important to him. In fact, it's probably more important for him to hang on to that 140 than a guy with 10 million to hang on to 2 million of it, if you look at it as a percentage of what he's got. So he's taking extraordinary steps to make sure that he doesn't lose these assets. Well, in 2009, he ends up in debt on the order of about $250,000. And by the way, most of this was medical debt. And because he's got this asset protection trust, he figures, well, let me just declare bankruptcy and get out of all this medical debt. And we run into Section 548E. And what Section 548E is it comes from the Bankruptcy Abuse Prevention and Consumer Protection Act. I like how they name these things, Consumer Protection Act, as if somehow this statute protected consumers. It does not. It protects banks. It protects creditors, or lenders, not creditors. So, this was written by the credit card industry in 2005. I remember when it came out, and it was horrendous. It made bankruptcy much more difficult to use, harder to use, and harder to benefit from. But what Section 548E specifically says is that assets transfers made within 10 years with actual intent to delay, hinder, or defraud any entity to which the debtor was or became indebted, and specifically mentions self-settled spendthrift trust. It literally took direct aim at asset protection trusts. And so what do you think happened? The bankruptcy court basically pulls out the trump card and says, I don't care, Alaska, about your statute. Federal bankruptcy law supersedes state law, and we want this money included in the bankruptcy estate. So frankly, the worst thing that this client did, whoever's client he was declare bankruptcy. If he had not declared bankruptcy and just let creditors try to reach his assets on their own, he'd probably still be enjoying them today. But instead, he tried to use bankruptcy, figuring he can get out of it all, and 548E just sucked it all right back in. And so, he makes a motion to reconsider. This fails. The appeal is filed. Ultimately, they reach a settlement. This is really a bad result here. It's not what we want to see. But it really makes the point that federal bankruptcy law and probably every other federal case in a district court, an appeals court, or the Supreme Court of the United States is going to trump the state asset protection. And while I can't tell you exactly how every case would turn out, I can use this case to interpolate, and I can definitely say I'm not super comfortable now using Alaska for a client. So there's a question I put at the bottom here, which is, are self-settled trust assets exempt under bankruptcy law if the trust is seasoned for at least 10 years? Well, I would argue that they are, because the 548E is really clear. If you want to look it up and read it, or better yet, go to assetprotectioncouncil.com, see the website at the bottom of the page there, and go under the resources tab and look up the case. Look up Batley versus Mortensen, and I actually quote 548E in the whole section there in its entirety, so that you can see what it says. I haven't seen a case on this yet. I don't think we've had any cases come through the bankruptcy courts on this, but I would say that they are exempt, because it's really clear. If it's made within 10 years, it's includable. If it was made with an actual intent to delay, hinder, or defraud a creditor. But after 10 years, even if it was made with an actual intent to delay, hinder, or defraud a creditor, by the words of the statute itself, it would be exempt from the bankruptcy estate. All the more reason why I encourage clients to set up asset protection trusts soon, set them up early, get them seasoned and aged as long as you can. And if you have a bankruptcy, if you have an asset protection trust and it's already been aged, keep it. Do not get rid of it. I had a client today call, and he's retired now, and he's had his trust for 11 years. And I just told him, my gosh, if I could sell this trust, it'd be worth $250,000 to somebody who needed it. Don't get rid of it. They're very easy to maintain if you've done it properly. It doesn't cost a lot of money, especially like his, if it's a bridge trust, which I'll explain at the end. So there's case number one. All right, so let's go to case number two, Kilker versus Stillman. This is a 2012 case, 1 year after. And the facts are that in 2000, Stillman, who's a soil engineer for pool construction, so he's in California, by the way, it's really important for this case, and he goes out and he tests the ground and he tells the pool guy, okay, this is good, you don't have to compact it or whatever. So, but these guys get sued pretty regularly because it's California. It's on a fault line. The soil shifts, pools crack, and next thing you know, people are wanting to point the finger. And it's California. And did I say it's California? California is the toughest state as a person with assets, as a person who runs a business. They just really have a target on your back. So 2004, he settles 3 Nevada irrevocable trust, asset protection trusts, funded with personal business assets. The main part here is he maintained control as managing director. Actually, that's not even really the important thing. The important thing is that they're all domestic trusts. They're all Nevada trusts, right? In 2008, 4 years after he settled the trust, he has and the pool, by the way, was done in 2000. So 8 years after the pool was installed in the house, the pool cracks and leaks, and the homeowners sue. And Stillman ends up settling for $92,500. Okay, well, there's his first issue, is that he settled. Well, once you settle, you need to pay up. You don't make settlements and then not pay. That was just an error on his part. But he was probably told, oh yeah, go ahead, settle, get this off your back, and then you've got these trusts, don't worry about it. So he doesn't pay up. And the homeowners go after a building that's sitting in his trust, and the building is in California. So many mistakes here. First of all, I wouldn't put a trust, a commercial building, directly in an asset protection trust. I would use a limited liability company first. I would have that in turn held by a holding company. I typically use an Arizona Asset Management Limited Partnership, again, to add more charging owner protection. Both of these would have done much better than just having the trust in direct control. And I reserve the trust for an escape if you have to. But putting the trust on the front line holding real estate is not the best idea unless it's your primary residence, and that's only because of the tax benefits of primary home ownership. So, well, of course, what do you think happens? Right before the sheriff's sale, the trustee flies in and thinks they're going to save the day, claiming, he's not the owner, the trust is, and they just don't go for it. They don't. And so the homeowners actually set this incredible precedent, which is that under CUFTA, the California Uniform Fraudulent Transfer Act, and the alter ego theories, that the trust should be disregarded. The court agrees on both points. and the fraudulent transfer claim. So now we have precedent in California which says that because a lawsuit was just reasonably foreseeable in the future, which means every doctor, every builder, every business person out there now, basically under California's interpretation, should reasonably foresee that they have, a chance of being sued. That was enough to trigger CUFTA. So, I mean, this is just horrible precedent, but that's what happens when you leave the power in the court's hands. And of course, the asset was in California, which was also in the court's hands. So, this whole case is just a really, classic bad facts make bad law. But nevertheless, that's what we got. So here we are. We're stuck with it. And Stillman appeals and argues that CUFTA requirement, requires an intent to defeat an existing creditor, which that does make sense, not future unknown creditors, and the court doesn't go for it. The court disagreed and upheld this whole reasonably foreseeable thing. The appeal argued Nevada choice of law. Of course, California said no. What big surprise there. And anyway, under the Uniform Fraudulent Transfer Act, Nevada would have come up with the same result, et cetera. The mistake here is, one, using the trust to directly hold the real estate and then trying to defeat a settlement, which he should have paid or come up with a payment plan for. Two, just using a domestic asset protection trust. Right there, I think is problematic. Now, after Stillman, I can't see how any attorney in their right mind for a California client could use a domestic asset protection trust, a pure domestic asset protection trust, because I believe this case just sets a precedent that it is, you would just be crazy to use a DAPT for a California client. I personally wouldn't use a pure DAPT with no escape route to a foreign trust in any jurisdiction for any client. That's just my opinion. But I like a little more certainty with my clients. I know my clients like that kind of certainty too. So that's how we work. So that's case number 2, which is just another failure of the trust and bad precedent on top of it. So now we have a bankruptcy exception for the DAPTs, and now we have a choice of law and a fraudulent transfer exception for the DAPT. Now let's look at case number 3, which is a really big one. It just came out last year, Dahl versus Dahl. You all are going to love this one. In 2002, husband settles an irrevocable Nevada trust, and then he funds it in 2003 with marital assets. He defines the beneficiaries in the trust as himself and spouse, but he doesn't name his spouse. He just says spouse, meaning whoever he's married to at the time. So this guy was already in his mind setting up that he's going to be able to have interchangeable spouses, and they'll just automatically become beneficiaries of this trust. So I have to wonder about his intent when you do that. And in 2006, 4 years later, they get divorced. Surprise, surprise. The wife sues the trust, fearing that she's going to lose the property in the trust. And at the time, of course, she signed everything because she saw herself as the beneficiary. But now she's explained to her that she is no longer spouse. She's now ex-spouse and therefore won't be a beneficiary. And by the way, this is a Utah case, and Utah is a domestic asset protection trust jurisdiction. So we're talking about Utah, which does have a DAPT statute, and Nevada, which also has a DAPT statute, which makes this case very interesting because this is 2 asset protection jurisdictions. So theoretically, you'd think that they would kind of respect the whole concept. So she loses at trial, and then she appeals to the Utah Supreme Court. So trial court actually agrees that, sorry, too late, tough luck for you. She appeals it up, which of course you can always do, especially if you've got jurisdiction and if the assets are all sitting here in front of the court. And the Supreme Court says, oh, no. Choice of law issue, if it's Nevada, the husband wins. If it's Utah, the wife wins. Well, we believe that there is an overriding public policy reason for us to apply Utah law. And therefore, we're going to apply Utah law. And therefore, remanded the whole thing to the trial court in order for them to relook at it and re-include the assets in the marital estate and redivide all the assets. So, again, if you leave it in the hands of a judge, expect it to ping pong back and forth, which we see here. And again, Utah has a strong public policy and equitable division of property in the event of a divorce. So the flaw. Husband reserved the unrestricted power to amend, therefore the trust was not irrevocable but revocable. Well, yeah, that's just a terrible thing to do, and an asset protection trust is an unrestricted power to amend. But I don't know that that would have even made a difference. That's, I think, the reasoning they use just to back and reverse engineer what they wanted to have happen here. So they remanded it. They said the assets need to be included. The wife could then therefore revoke this trust and revoke her contributions, etc. Again, I said it, Utah is a DAPT jurisdiction, but the family law court was involved. They didn't really care. They weren't trying to make great precedent for Utah. They were trying to solve a family law issue. And this is another thing that I think everybody needs to really keep in mind. If you're using a DAPT statute for a client in that jurisdiction, everybody goes, well, that's the one time I would use a DAPT. It is if they live in the jurisdiction and we use that jurisdiction. That does not guarantee that you're going to get even the laws of that jurisdiction respected, because you might not be in a court in that jurisdiction who really gives two bits about whether there's good precedent or bad precedent for Utah regarding domestic asset protection trusts. And here we see they didn't, because it's a family law court. I think choice of law and result-oriented judges remain the fundamental weakness of all domestic asset protection trusts. I just personally don't know how I could confidently tell a client that because we've got this domestic asset protection trust, you can feel really, really confident that you're completely safe with your assets. This really gets back to what are the lessons learned here. DAPTs may violate the public policy in certain states like California. They have failed when challenged. We just saw 3 cases in which that happened. By the way, those are not the only 3. Those are just the 3 that we decided to choose today to go over. And since a DAPT jurisdiction cannot simply disregard non-DAPT courts, in other words, Nevada cannot disregard California. They just can't. Cook Islands can disregard California because the Cook Islands actually statutorily is required to disregard California, whereas Nevada is constitutionally required to respect California. That's the big difference. Poor drafting here, not getting good advice up front. I didn't read the trust itself. I don't know how well it was drafted, the actual trust. I just think the overall plan was just, flawed because it didn't utilize the domestic tools that have good charging order protection, the LLCs and the limited partnerships for the real estate, and then they just tried to stay domestic. A lot of people also, I want to talk about this third point here. They say, oh gosh, you can't do things with asset protection as the only purpose. You need to have business planning and succession planning and estate planning included when we do asset protection planning. I don't think that's going to make a hoot of difference if you're sitting in a court that wants a result. I don't care if you did your estate planning at the exact same time. I don't care if you made your entire asset protection trust look like an estate planning trust. You gussied it up and put lipstick on it. I don't think that the courts are that stupid. I think that if a court wants a result, it's not going to matter. So my opinion is, yeah, it's nice to have those things. It's nice to do your estate planning in conjunction with all of your wealth preservation, and you can call it asset protection or you cannot. First of all, asset protection is legitimate. We've got 16 states with statutes that allow it. We've got court precedent that says it's a legitimate purpose. So I don't think there's anything wrong with being honest about what you're doing. I think that the real protection you have is not leaving this in the hands of a judge in the United States, because that's where the risk comes in. And I clerked for Jack Weinstein, the Eastern District of New York, district court judge, federal district court. And he wrote Weinstein on Evidence. He was the master, the giant volumes that all of us used in law school. That was him. An incredible judge, a legendary judge. And I watched him he wanted a result. He would decide the way he wanted to decide. And at one point I watched the counsel look at him and say, but that is directly opposed with exactly what the statute says. And he just looked at him and said, take it upstairs, meaning appeal me. And that's what a judge can do. They have that power. Some of us who don't spend a lot of time in the courtroom sometimes forget judges have the power to make decisions contrary to even statutes, much less precedent. They can also use the court of equity to decide things that are just absolutely not the way the statute says to decide it. And so, my philosophy is don't get there. Don't be in front of that judge with all your assets hanging in the balance, hoping that that judge looks at it your way, because I can't tell you if he will or she will, and no one else can either. But frankly, I think the balance is against you, because if you're the guy with the assets, usually I think you come out behind on those cases. So anyway, and then of course, don't use asset protection to cheat people. I mean, that's just foolish. And I certainly, in my planning, create clawback provisions and exceptions for if someone got a hold of one of my trusts and they really were a scammer. I'm designing my trust not to protect those kind of people. I don't want them as clients. I don't think any of us should want those and encourage them as clients. If you've got somebody who's really, defrauding people, that's, you don't want to give them access to this kind of power. Asset protection trusts are incredibly powerful if done right. And then finally, I mean, in my opinion, you've got to be able to get out of the U.S. And this gets down to the bridge trust. So the foreign trust starts foreign, is a fully foreign asset protection trust, has all of the foreign filing requirements, 3520, 3528 annually, the FinCEN 114 if you have offshore bank accounts, all the FACTA disclosures if you have offshore bank accounts. The costs are going to be higher typically than a domestic version, and certainly than the bridge version. And it's just, it's just got more management to it, because you've got this offshore trustee that's in place and is involved in the trust right from the get-go. It's the safest. And if I'm defending a trust, which I have dozens that are already triggered offshore and being defended, that's where I want to be. And I feel extremely comfortable with that. But for most of my clients that are really just putting this in place for a potential problem in the future, they're not trying to, avoid anything right now. They just want to be safe. That type of maintenance is a little bit excessive. And so what I've done with the bridge trust is we've created a trust with the strength of the foreign asset protection trust, but the simplicity of a regular domestic grantor trust. And when I say domestic grantor trust, I'm not even talking about a domestic asset protection trust where you would need a Nevada trustee. I'm talking about like a revocable living trust, that easy to maintain. And the clients can maintain control of that trust until and unless a crisis occurs. There's no foreign IRS, FinCEN, or FACTA filing requirements until the trust is actually triggered. It's tax neutral domestic grantor trust, which is disregarded as a taxed entity. It's includable in their estate. We're not playing any kind of income tax games with it, nor estate tax games. It's very straightforward from a tax standpoint and from a control and compliance standpoint. It is very easy for the clients to maintain, and it is very easy for you as their attorney to maintain with them. The trust holds the settler's assets either directly or mostly through LLCs and through a master limited partnership, an asset management limited partnership, which kind of holds all their assets. The Cook Islands trustee is already in the trust document. They've already signed as the special successor trustee, which means they already have agreed to accept an incoming trust in the future, even if the settler is being sued at that point. And the trust is registered offshore, but it's brought back in for administration purposes. So it's a domestic trust. How does that all fit together? Well, here's the asset management limited partnership in the center. It can hold the liquid assets, the brokerage accounts, all your savings, etc. There's the bridge trust, which is going to typically, in our example here, it's the 98% limited partner of the asset management limited partnership. You still have your revocable living trust or your estate planning that you're going to do normally. And then let's say you have LLC, 1, 2, 3, 4, 10 LLCs, whatever it is. The LLCs are going to be owned by that master holding company, the asset management limited partnership, and that's going to be owned by the bridge trust, which, by the way, this is exactly how I would have set up that case, the Stillman case, with the office building. I wouldn't have put it in a Nevada asset protection trust. I would have put it into a California LLC. And at that point, even if he did renege on his settlement of $92,000 and they went to collect against the California LLC, that had a much better chance of being respected than the Nevada Asset Protection Trust ever did, because it's a California entity. California courts actually understand those, and they know, oh, well, this is a charging order protection. If it didn't, you'd have the Asset Management Limited Partnership in Arizona, is a jurisdiction which has great charging order protection as an extra backup. Then you'd have the bridge trust, which the courts would not see and know about unless we triggered it. And so we wouldn't be bringing down the wrath of the courts on our clients because all they see is this asset protection trust holding the assets. We would have these normal entities, LLCs and limited partnerships there. And the bridge trust is really behind the scenes, invisible, no tax return, no foreign filing requirements. It's just very quiet. But if we have to trigger it, we can trigger it. And at that point, the assets can move off to the bridge trust and be really protected. This is the structure I've been using since we began practicing in 1997. I joined my father, who had been practicing for, 20 some years, 25 years before that in the area of estate planning, business planning. And he came upon asset protection very organically. He had lots of limited partnerships with clients that he had set up for investing in real estate. And when the savings and loan crisis in Arizona occurred in the mid 80s, a lot of those clients ended up using those limited partnership interests as leverage to settle what otherwise would be bankruptcy estates. And so, it was a very organic growth for him as he realized, wow, this is powerful. And then he started looking at how can this be even improved. So, I've been doing it since 1997. He's been doing it much longer than that. We really have a great history of asset protection. It's the only area I've ever practiced in, as well as the estate planning that we do along with it, and certainly the estate planning that our affiliates do. But this is our focus, and we've really focused on mastering this point of the process. And I want to kind of go over one of the things that I hear affiliates asking me a lot. In fact, I had a call with one recently. I said, how do you explain to clients, why would they pay $25,000 for your plan? How do you explain that? And I say, it's not about paperwork. If a client comes and they want the paperwork approach, or what I call the document approach, where they just want to get these documents in place, they've read about a Nevada trust or something, or an LLC, and they're calling and they just want the cheapest way to get these certain names in place because they think they're good because they read about them in a magazine or online. That's not what we do. You can go to LegalZoom, you can call a trust company in Nevada, and they'll send you a sample trust document. And this applies to attorneys as well, looking to add asset protection to their practice. You can find sample documents anywhere and everywhere nowadays. That's not the magic of asset protection. It's part of what you need to do. It's the prerequisite to the magic. I mean, you have to have documents that work, that are correct, that are well drafted, that are in the right jurisdictions, and that are maintained properly. But the magic is how you actually play this poker hand. Because asset protection is not roulette. You do not put your chip on black or red and spin the wheel and you win or you lose. It is poker. You do not have to have the best hand to win. You have to play the hand that you have the best. And that's what we do very well. We've got a lot of experience, thousands of cases of playing poker hands with clients and understanding how this really works in real life. And again, it's not about whipping out your trust and telling them to go pound sand. It's about properly using your documents to provide the strength to your primary litigation attorney, helping them understand how they can change the way that they are playing their hand because we have backup. And ultimately, if we have a judgment and we have collection actions against our clients, how do we actually use it? And running to the bankruptcy court is virtually my last response. I mean, I am almost never encouraging a client to run to a bankruptcy court. It results in, the Mortensen case where, you end up in bankruptcy and the bankruptcy court just kind of throws everything you've ever done out the window. So that's what I say is that clients who choose to work with us do so because they're coming for a result. They want to protect their assets, and documents are a part of that. but choosing the right firm and putting together the right team is what really makes that work. And so I really commend you all as attorneys who are adding asset protection to your practice in doing it this way. You're doing it the smart way. You're partnering with a firm that has the experience so that we can together get this right for your clients, so that when some percentage of those clients have to use this planning, which I promise you they will, they will, you know that it is not going to explode on you, that you have the right team that can literally play that poker hand with the client, walk them through, and give your client the best chance at the best possible result. So I really want to commend you all for taking the time and effort. I see your names on the webinar here. You guys are the smart ones. You are getting educated. You are partnering, and I can tell you I've worked with many of you already. I really enjoy working with you. This is so much fun, and for the first 15 years of my practice, I was just working with clients. Now that I've started working with attorneys, I have to tell you I enjoy it much more. It's just great because I still get to work with the clients. I still get all the unique experiences, but now I have partners, and I have partners all over the country. And I've also started to see how valuable this network of attorneys that are learning the same things and that are getting this good information is to each other. I can tell an attorney in California who has a client moving to Atlanta, I've got a great referral for you to give your client for help that they need because they're going to buy an office building in Atlanta. This network is really turning out to be just a great network of support for all of us. So I also encourage you all, we have launched the new AssetProtectionCouncil.com website. You can go there, AssetProtectionCouncil.com, and you all, if you have signed up and you are an affiliate member, you can get a web page under the member directory, and clients can search you directly there. We will be more and more becoming a direct destination for asset protection information for both attorneys and clients, potential clients. So you really want to have your web page up at AssetProtectionCouncil.com. So I really encourage you, if you haven't, to contact Kitty, get her the information. We've also got a great online login where you can log in, you can see all the clients that we're working with together, you can input their information to start a new client. There's a file box where we can transfer secure documents and even deliver them to the client that way. So there's just a ton of resources that are available to you by being a member of AssetProtectionCouncil.com. And I just want to thank you all for taking the time to educate yourself and to be involved. As you know, I love talking to you guys. So if anybody wants to call me, set up a time to speak, and just want to do an individual conversation about particular clients that you have that you think you may want to get a joint conference call and an analysis going on, or just strategy that you want to use for your own marketing of asset protection, I'm available for that. Mark Lodmell is available for sales training. Ian is available in my office. So we are really here to support you. It's becoming more and more the major focus of what we do. So please use it. Utilize that resource. All right. So I want to thank you all again for joining me on this first Thursday. I look forward to speaking with you individually as well as seeing you next month for the next first Thursday. Look out for the next topic on that. We will continue to go and explore the world of asset protection. Visit AssetProtectionCouncil.com and make sure you get yourself your webpage on there and contact Kitty to make sure that you are fully signed up and ready to go. Thank you again for joining me, and this webinar will be posted at AssetProtectionCouncil.com so you can review it, or if you missed it, you can review it for the first time there. Thanks everybody. Have a great weekend. Happy October. Have a great Halloween, and I will see you guys next month.